Word on Wealth Radio Network. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here's Gary.
All right. Welcome to the Word on Wealth, everybody. It's great to have you along. We have this, by the way, we're running this live on YouTube if you want to review this information. Today, there are different kinds of trusts. Have you ever wondered, what should you do if you have a child, maybe who you would consider like a prodigal son, a prodigal child that just can't manage their money? What if you were really charitably minded? Are there different types of trusts for people that have great ambitions for giving money to charity? What if you have an heir that if they receive money, it's going to be taken up by government disability? Where do you start? That's what we're talking about today. There's different types of wills and trusts. Specifically, we're going to get into the trust part of it, but I want to first clarify what is the big difference between a will and a trust, and then talk about some specifics of trusts that are very different. Because I think it's good to know that stuff. If you guys, I know a lot of you listening have your own trusts, which is fantastic. Everybody that has children should have a trust. Everybody that has real property in California worth more than $50,000 should have a trust. Anybody that has beneficiaries who are going to receive money and they're under, 25 or 30 years old, you should have a trust. There's just a lot of different reasons. Trusts are affordable. They take some planning, they take some time, but it's one of those things where, hey, we're all going to die, and we're going to die sometime. We don't know when, some sooner, some later, but let's get this stuff together. That's why we have the show. If you have questions for me, you can call 888-344-1170, 888-344-1170. Ask me your questions here directly on the air, and I will give you the best answer I can. 888-344-1170. We still have lines open for you to call and talk to me. Wills and trusts. A lot of times we just we say, oh yeah, I have a will. And do we have a will or a trust? And there's a big difference between the two. A will, if all you have is a will, which is great, it's better than having nothing. But a will doesn't have any force or effect until you die. A will goes through probate to have the court review the documents, the property, the values, who's in charge, how much money people are getting paid. That all goes through probate. It's not necessarily wrong to have your estate go through probate, but it is phenomenally expensive. And it could cost 3 to 6% of the gross estate or more. Potentially up to 8% of the trust could go to probate fees and costs. Also, if it goes through probate, you lose control and you lose privacy. If you have a trust that's properly drafted and you got property put in your trust properly and legally, then it will avoid the probate process. We don't have to go to a judge to get those decisions made and figure out what's supposed to be going on. And the other thing about a will is that there aren't that many variations. It's a last will and testament says, when I die, do this. Trusts come in all shapes and sizes. And depending on your needs and the needs of your heirs, the trust can do a lot of different things. See, a trust is not only effective on your death. A trust is effective once you create it. It's effective during your incapacity, and it's effective after you pass away. So having there's just a lot more flexibility with trusts. They're a little more complicated. That's the disadvantage, but that's okay because we are just trying to get our flexibility and determine, what's the best way to go. There's a couple different types of trusts. In general, you have trusts that are revocable and trusts that are irrevocable. Okay, a revocable trust is kind of like an umbrella. It's this umbrella that puts protection over all of your assets and all of your family members. Revocable, the whole concept means it can be revoked. Because it can be revoked, that means it can also be changed. So when you hear about a trust that is revocable, that means it's a changeable trust. It can be amended or changed by the creator. So if you create your own living trust or have one created for you, then you're the creator or the grantor or the trustor, same person. And because you created it and you're the beneficiary, in other words, you can use all the property. You can still use the house and the car and the boat and spend the money. You're the creator, you're the beneficiary, you're also the one in charge. So you're the trustee as well. Because you are the trustee and the beneficiary and the creator, your power is unlimited on what you can do. You can spend money on whatever you want. You can buy and sell assets. You can put assets in the trust. You can take assets back out. While you are doing all that, it is amendable. It is a revocable trust, and it can be amended or changed by you. Okay. Once those factors change, it can become an irrevocable trust. So we'll talk about irrevocable trust a little bit later in the show. Irrevocable means it cannot be changed. That means it can't be amended. You can't change the wording, and you can't change the stuff that you've irrevocably put in that trust. Some of those things you have to be really careful because they're controlled specifically by state law. California is much more restrictive on irrevocable trusts because of some of the effects that they have. Okay, so what are some varieties of trusts? We have revocable, irrevocable. If you have questions on this, you want to ask me on the air, I'd be happy to take your call. We got lines open at 888-344-1170, 888-344-1170. Give me a call. Let me answer your question. All right, what if you have a blended family? Pretty popular thing to have nowadays. And, you know, we're talking 2022, there's a lot of blended families. That's where the husband might have children and the wife might have children, and they may have children together. But because of the marriage, we're blending this family. So it is probably more common with estate planning to have husband has children and wife has children, and they don't have any children together. Anyway, that can take care of things. Okay. A lot of times when we have a blended family, we want to have a Q-tip trust. Not a Q-tip, not the thing that you stick in your ear to clean out the earwax and stuff. But it means qualified, terminable, endable interest property, qualified terminable interest property. So Q-tip. The Q-tip trusts are ones where you set it up where when the first person dies, that person's interest is in a trust, and it's providing for the use of the surviving spouse. Example, husband and wife get married. They each have 2 children. Okay. Husband dies. Well, his children are going to get his half of the house and all of his separate property. That's the way their trust is set up. However, he doesn't want his wife to have to move out of the house just because the kids inherited half of it. Her kids inherit the other half. So he's dead. Does she have to move out of the house? No, because you can have this Q-tip trust that says that the house, his half, stays in the trust for as long as wife needs to use it. And you can put restrictions and say, wife can use it as long as it is just her, as long as if she has people come and live in the house, it's not for more than 2 weeks, or you can say not more than 4 weeks a year, and they can't be, weeks that are, 4 weeks in a row. There's so many different restrictions you can put, but pretty typical is it would say husband's half of the house stays in the trust, available for the use of his spouse, the wife. All right. So the wife has that use of that property until she decides that she doesn't need it anymore. It's too big, doesn't want it. The market is great. So if she sells the property, then her half goes to her children and his half goes to his children. So it might be years later before that occurs, but when that event occurs, his kids still get his half of the property. That's a Q-tip. And there's other ways that you can do that. When you set up things like Q-tips, you can put, other protections in there also, that the beneficiaries can make sure that the wife is taking care of the property. You can give her discretion to do whatever she wants, or you can have some limitations. Also, what happens with Q-tips is, let's say when husband dies, let's say he had the most of the money and he wants to leave money available for his wife for as long as she needs money. But when she dies, now his money goes to his children. You can have a Q-tip trust that provides that also, so that she has that money available to her, and she can make sure, or he can make sure that she is taken care of during the whole time that she's alive. Okay. And vice versa can happen too. Obviously, wife dies first, she leaves her half of the house. Now, I've done trusts with Q-tips where you have husband has his own trust, completely owned trust. Wife has her completely owned trust. They each have their own stuff in the house. Each of them had property. Each of them had a house. One of them had more than the other. It didn't really matter. But each of their trusts allowed the other one to live in their half of the house for their life. So the trusts look very similar, and we call them reciprocating trusts, where we draft two trusts that are parallel. The first death distribution. So let's say, let's go back to husband dying. Husband dies. His trust says everything goes to my kids, and everything goes to his kids except for what's in the Q-tip. And the Q-tip has a house in it, and it has $100,000 or whatever, the $500,000 investment account. That stuff's in the Q-tip, so that surviving spouse has the money to live and survive until she doesn't need it, until she gets remarried, until she dies. And then all the money, his half goes to his kids, her half goes wherever her trust says it would go. And typically that would be to her own children. So that's a Q-tip for blended family. Another case, what if an heir is disabled? Okay, you have a grandchild, and you figure if you give a bunch of money to one of your kids who has a grandchild that is handicapped or disabled, and they're receiving some type of government benefits. California has great government benefits for incapacitated kids, for handicapped kids. And I know that, we call them special needs children, special needs beneficiaries. Those are all things that are available where there's going to be some government programs potentially. Okay. If that child inherited money, so this is a grandchild, if that child inherits money from grandpa or grandma, it may forfeit any benefits they get in the future. So instead of giving it directly to them, grandpa and grandma create a special needs trust for that grandchild, so that grandchild has money available, but it's only available under certain restrictions, and the restrictions are complied with by the successor trustee. Okay, that's a special needs trust. Now, coming up next, I want to talk a little bit more about special needs trusts and how great they are. And also I want to talk about a prodigal heir. What if you have a wasteful heir that's going to get some of your money? Coming up next here with Gary Quackenbush on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush of GQ Law. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do audit reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. gqlaw.com, 855-500-TRUST. gqlaw.com.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. gqlaw.com.
All right, welcome back. This is Gary Quackenbush on The Word on Wealth, and we're talking about special needs trusts and what that means. A special needs trust is created for a special needs beneficiary. Again, you may have heard of a special needs trust because you know someone who has a child with special needs or there's some issue like that. Well, I have a very good friend of mine who has some children who have some special needs, and the kids benefit from some of the great programs that they have in the state of California for children that are challenged and that have special needs. Well, what would happen is if this friend of mine, if he and his wife died and left money to their special needs son, that special needs son would now have too many assets, and any government benefits that he would be receiving would be cut off. Now, we don't want that because this special needs beneficiary needs to be around for a long time and needs someone to take care of him. What we did is set up a special needs trust. And when mom and dad pass away, any money going to this particular child, whatever his share is, doesn't go directly to him. It goes to his special needs trust. The special needs trust has a trustee who is now in charge of taking care of that money and making sure that it is only spent on behalf of the beneficiary without forfeiting any government benefits. Now, it's not really this way, but the way I like to describe it is a fun money trust. Okay, so it's for fun money. And I don't mean that in any derogatory way. It's just, I have to think of things very simply to help me remember. And, that's what I'm thinking, fun money. Okay. So for example, let's just say mom and dad have passed away. Now understand why, while mom and dad are alive, they can do anything they want with their money. They could take this child to travel and give them these great life enhancement experiences by traveling, going to Disneyland, going to Disney World, flying different, wherever they want to do, because it's their money. Well, the problem is when they pass away. When they pass away now, if you want to have that child to have enough money to be able to continue to do things that mom and dad did with them, the life enhancement things, the travel and all that, then you're going to need to have money left behind to take care of that. Well, if the money is left behind and it is directly accessible by that child, all their benefits, all their government benefits are going to be suspended, terminated until all the money is spent. And then when he's out of money, then you do a reapplication to see if you now qualify for the government benefits. The challenge is going to be that the successor trustee is going to have to figure out how to spend down that money. Better way to do it would be, don't put money in the hands of a special needs beneficiary, especially one that doesn't even know how to handle money. So you put it in a special needs trust and the trustee is in charge of it. It's in behalf of that special needs beneficiary, and the trustee only spends money on the things that will not forfeit benefits. That means it can be used for what I call fun. So could be for travel. It could be to pay for companion travel so that their caretaker, the person that's watching over them, can go with them and pay for the admission and pay for the fun and all that kind of thing. So the money can be spent on their behalf and for their benefit. They just can't physically have access to that money. So in that way, special needs trusts are really awesome. And they can be used in other ways. Also, if you have a beneficiary that is just awful, okay, just terrible at spending money, that's going to be our next situation. And that's where, if your heirs is a prodigal child, okay, prodigal just means wasteful. I learned that when I was teaching, religion classes, and I was thinking, oh, prodigal, that's the son that had all this perspective, potential, and when the prodigal son came back, that was it fulfilled his potential. Well, true, he fulfilled his potential, but the prodigal was the wasteful son, the one that took his inheritance, went away, spent it doing dumb things, and then luckily had a forgiving father. But if you have a prodigal child, a prodigal heir that's going to get money, it's not a great idea. In fact, it's a terrible idea to just leave money to that child. And I've had people say, you know what? I don't care. I will be dead. And if he wastes the money, that's not my problem. But I've had more than that would say, that is my problem, because if when I pass away and he has all the money that I've been saving my whole life, he's going to spend it on things that are going to not enhance his life and not even prolong his life, probably shorten his life. And so you can put money into a trust, a special trust for that child. So it's like if you have 3 kids and one of them is the prodigal kid, you split the estate in thirds. 1/3 goes to each of the other kids, and then the 1/3 for this wasteful, can't control money, spends it like it's going out of style trust. It's set up in a separate trust for that person. Okay, it's watched over by the trustee, and the trustee's controlling that. Now, sometimes you don't want a family member to do it. You don't want like their big sister, their little brother, or something like that handling their money, because that'll just become a nightmare for them for the rest of their life. A lot of times you do it through a trust company, or you have a private professional fiduciary that's handling that money, or even an institutional fiduciary, and they'll handle the money and only give out the money as necessary. And they're the ones that make the determination. And yes, it costs money because they're professionals, but whether you have a professional or an amateur, they're going to get paid because trustees don't have to work for free. They don't work for free. And so sometimes we want to get a professional fiduciary involved. So those are just different options. If you have questions on this, we've got lines open. You can call us at 888-344-1170, 888-344-1170. Call and ask questions regarding this kind of stuff. I'd be happy to take your call. So that's the prodigal heir. What about the philanthropic minded? Not a cool word. That means somebody that really likes to give money away. So if you like to give money away, you can set up all kinds of charitable type trusts. Some of the charitable trusts give money to the charity ahead of time, like during life. And there's an agreement that says, if we give you this money during life, you agree that when we pass away, you'll give money back at a certain rate. Or while we're alive, you can give money back at a certain rate. So there's different types of charitable trusts, which I think are really awesome. I've talked to clients that will say, it took me 50 years to put this money away. I'm not about to just hand it to my kids and so they don't have to work, because it's enough money. They won't have to work another day in their life. And I don't want that. I want to give money to institutions where I know it's going to be spent carefully. And I know that the administrative body is going to make sure that the money is spent carefully and very frugally. And that would be some type of charities. So they give money to charity rather than all to their kids. And I don't mean all of it, but it's kind of like, grandfather Hilton that was giving money to Paris and her sister. They were going to inherit like 40 billion, but he amended his trust to give them only 40 million. And they were freaking out and in the news and crying and all that other stuff, which is hilarious because they're only getting like 40 million. And I don't remember the numbers, but it was something crazy like that. So he gave the rest of his in his trust. He's giving it away to organizations that will spend the money wisely rather than granddaughterly. Anyway, crazy stuff. People that have lots and lots of money sometimes struggle with trying to figure out what to do with it. And I think you can set up trusts for your prodigal heir. And this might be a grandson, granddaughter, great grandchild, who knows, but you can set up trusts that make sure that the money would go to other than to children. And you can also do it in combination with that other trust we're talking about, the prodigal son, prodigal heir trust. So money goes to in trust for the prodigal heir as long as it gets spent wisely, or you can just give it away to charity so that it gets spent wisely for sure, or a combination. And all these things we're talking about, they can all be in the same trust plan, the estate plan, so that you can have multiple things going on at a time. Here's a kind of trust that people talk about quite a bit, and that is asset protection trusts. Now, California has some very serious restrictions on whether you can do what we call full asset protection trust. And that would be that you have real property and you irrevocably transfer it to a trust so that it makes it so that nobody can have access to that. And, you transfer the trust, you transfer the property to the trust irrevocable. You're trying to keep it so that you won't be sued. And then you have a corporate entity serve as the trustee. So that way you can never get the money back. It's available for your use, but you got to be careful with things like that. Yes, those are called asset protection trusts. The idea is to make it so that you have the money in somebody else's professional hands rather than yours. And there's some timing requirements on it. You can't do it, you can't do it while you're being sued. You can't do it when you suspect you're about to be sued. You can't do it when you think there's a claim. I mean, it has to be done years ahead of time. So if you do have concerns about litigation, that's definitely something to think about, is trying to figure out, what are you going to do? And can you use a trust? Is there a way to get some of your, all of your assets put away so that you aren't subject to litigation? A lot of this is insurance. A lot of it is people need to be insured. You can use corporations or LLCs to try to protect your assets. And you can combine that with your living trust so that you can have some asset protection that way. So California, New York, Texas, they're kind of restricted on what you can do with asset protection trusts. But there are ways to do it as part of like a complete estate plan. Okay. The next thing, with life insurance, there are ways to set up trusts with life insurance that make it so that you can have a trust that pays out, that receives life insurance and that type of thing. So you can do that. You can set up a trust, and we call them sometimes an irrevocable life insurance trust, where the beneficiary is the trustee of the trust, or the beneficiary might
minutes.
be an heir. It just depends. There's a lot of different ways that you can set that up so that the trust itself might receive insurance proceeds, so that then it can now be controlled by the trustee in paying out money to the beneficiaries. Okay, so let me go over that again. Life insurance can be used to go into the trust to make it so you have an asset that's big enough in that trust to control it. How many times do you talk to somebody and they say, well, I don't need an estate plan. I don't have an estate, and they may have kids. They may not own a house. They may not have much money invested, but they just figure, I don't have an estate. There's nothing to plan. Well, first of all, they have children. They need to have a trust. With the estate plan, what if, when are you going to need this money? Are you okay now? Financially, you're doing okay. When are you going to actually need the money? You'll probably actually need the money when you pass away. So let's get life insurance, and the life insurance pays into the trust so that if you die, $1 million goes into your trust. Okay. So life insurance, beneficiary, trustee of the trust, you pass away, $1 million, $500,000, whatever you have, couple $1 million, that goes into your trust. And now what do you have? You have $1 million or $2 million estate that you leave for your children and for your spouse, and they can be taken care of for the rest of their lives. So that's one thing you can do with, life insurance payouts. Instead of giving it directly to a beneficiary, put it into a trust and have that controlled by a trustee. All right. Coming up next, we are going to have Rich Mathurin from GQ Law come in. We're going to be talking about tax court. We talk about stopping foreclosure. We're going to get into some money issues and some tax issues coming up next here on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com. To request your free consultation or to talk with a member of the GQ team. That's GQLaw.com. 855-500-TRUST.
All right. Welcome. This is Gary Quackenbush, and I have my associate, Rich. How you doing, Rich?
Great, Gary. Good to be here again.
Yeah, thanks for coming on. Rich is our, I would say, Rich is our feature. Rich comes onto the show every Monday. We're talking about the Word on Wealth, and our goal is to talk about how to build, protect, and transfer your wealth. And one of the things that Rich and I have been talking even before the show is that during the pandemic, there's just so many things that happened that were just kind of, I guess, a lot of can kicking down the road, right? I mean, mortgages and stuff like that. And so talk to us a little bit about that. What have you seen kind of during the last couple of years during the pandemic? I mean, what are these things that have been getting kicked down the road that now we're starting to see that are kind of coming home to roost?
Well, many people got COVID forbearances from their mortgage lender where they could stop paying their mortgage for a year. But I think the understanding that most of the mortgage companies had was that once the forbearance was over, a year, 9 months, whatever, then the arrearage would become immediately due and payable. Some mortgage lenders will have an agreement to tack it on to the end of the loan, but a lot of them have been saying we want our money now type of thing, and it's created a lot of chaos. I've been this is a perfect time. I've been working on like 4 of these cases right now, trying to kind of work it out with the mortgage lender in a current bankruptcy, and it's a big problem, and you do need clarification because these mortgage forbearances, it doesn't get you off the hook from paying all that money for a year that you didn't have to pay for a year. It's just like you said, kicking the can down the road.
Yeah, I think so many times it just seems like what we've been seeing is that it's during the pandemic, there's so much forgiveness, so much, we're getting sent money. We had these stimulus payments. We had, don't worry about paying your rent because you can't get kicked out. And then your landlord can ask for money from the government. There's just a lot of that kind of stuff. I think we're almost kind of still in that mode, thinking that, oh, that's okay. If they go to foreclose my property, then the government's going to step in and say, oh, you can't foreclose the property. But, we've been seeing just the opposite. I mean, they're not playing games anymore. They're saying we're selling your house, and they're setting up sale dates.
Yeah. I have one particular big bank that'll go unmentioned, but they've had a lot of problems with homeowners in the past, and they've been incredibly aggressive. I think they filed 4 relief from stay motions on the current bankruptcies, and they've been very, very aggressive about trying to foreclose on my clients. And I've been working with my clients, this bank's counsel, the bankruptcy trustee, to try to work these things out. But they're vicious, and bankruptcy does provide a lot of protection where the mortgage lender has to work through the bankruptcy court if they want to do anything, whether it be a foreclosure, or they would have to get a relief from the automatic stay to do any foreclosure proceedings. And you can work with the counsel to get the arrearage paid through the plan, or get more time to sell the property. So the Chapter 13 bankruptcy is a lot of times a good suggestion for people that have an imminent foreclosure.
So let's talk about that then. With you mentioned a couple of things. You mentioned the automatic stay, and you mentioned Chapter 13. So when their house is going into foreclosure, the process is that the lender is not being paid. So the lender's going to give a notice of default. It's going to be recorded at the county recorder's office. It's going to be basically nailed to the door. Not really nailed, they're using blue tape, but they tape it to your door. And then that's going to give you 90 days. And at the end of 90 days, they can issue a notice of sale. So we're talking about 120 days. Yet what we see is that we don't see people calling us up with a notice of default. We see people coming in and saying, oh, I have a notice of sale. So we're 90 days further down the road. And I think, you're talking about this automatic stay. So let's say they get their notice of default. They're going, oh my gosh, I don't know what to do. They're trying to do their research. They're talking to their friends at the water cooler. What do you do? What do you do? And of course, people are saying, oh, don't worry about it. Somebody will take care of it. But then they're 90 days later, get this notice of sale that says, hey, we're going to sell your house on the courtroom steps in 21 days.
21 days. I've had people come in on a Friday when the foreclosure was Monday.
So, but how does a bankruptcy stop it? Because you talk about the stay. What does that mean? And how does that stop the foreclosure?
Immediately upon a filing of a bankruptcy case, whether it be a Chapter 7, that's liquidation, or a Chapter 13, that's the reorganization. And a filing puts into place what's called an automatic stay. That stops all collection activities by any creditor. They can't levy your bank accounts. They can't garnish your wages. They can't foreclose on your property. They have to do everything through the bankruptcy court. They have to motion the bankruptcy court for what's called a relief from stay, and that allows them then to take collection activities. But the relief from stay process can be a 3-6 month process. And a lot of times you can either work out something where we go into the Chapter 13 and pay the arrearage through a plan, or the alternative is we probably can buy you 6 months where you can sell the property at its fair market value and realize any equity that you have in it.
So the stay is like an injunction. Then it's basically this. I always think of it as stay back, and the creditors have to stay back. They can't. So if they're doing the foreclosure, that's this legal process where they're trying to take your property. You file bankruptcy and the court says, stop stay. So the bankruptcy, it's not like a dog quite, but the bankruptcy court is basically saying, stay your procedures. They are stopped and you can't move forward without going through the bankruptcy court. So that happens in a chapter 7, chapter 13. So if you're getting evicted, that's going to stop. If you're getting foreclosed, that will stop. If you have a collection activity from the IRS, that will stop, right?
Yes.
Okay. So then if the IRS is, if they're now taking your wages, or if a creditor is taking your wages, that will stop.
Yes. And you probably can get, if the last 3 months, you can, if they've already garnished your wages, you can usually get that money back for the estate, depending on whether that would be exempt or unexempt property. But you usually can get that money back through what's called a preference motion, or get that money back.
So these are all tools that are available in U.S. bankruptcy court. And so because we're kind of switching into, you got foreclosures, you got creditors, and then what we deal with a lot at GQ Law are the taxes. And that's kind of mostly where we end up seeing the problems, is that people have tax issues. So the IRS doesn't foreclose on a house. The IRS takes wages and bank accounts, and they file liens, and they cause all these messes. So we wanted to make sure that our listeners knew that, it's not the end of the world. I know it seems like, oh my gosh, death is certain, taxes are certain, but there are ways to stop this stuff. There are ways to control it. Now, we're not saying that you could file Chapter 13 bankruptcy and then just keep your house without paying. We're saying that you're running down the road. You just feel out of control because there's a foreclosure, there's a sale coming up. If you don't do something, right? If the foreclosure sale goes through, lenders don't show up and say, hey, we want to pay full value for this thing. They show up with less than fair value.
Yeah, it goes through an auction. So you're going to get auction value basically. And then the lender can charge you for their attorney fees, for their foreclosure fees and things like that. Mm-hmm. So it adds up, and your net may be zero, or, you may be owing. You would probably be, if you were in a bankruptcy, you would be discharged from any excess beyond the sale price. And I think California does have a law in that respect. So you would only be liable up to the amount of the sale proceeds. But I have a client now.
So you lose all your equity.
Yeah, I have a client now that he was being threatened to be foreclosure and a relief from stay motion. But we worked with the creditor, with the lender, and with the Chapter 13 trustee, and he was able to sell his property for a good amount. I think he's going to walk away with like maybe $500,000-$700,000 after he pays off his mortgage, after he pays off the IRS and some of his other creditors. That's a good nest egg to move forward. So,
and if he hadn't done that, if he'd let it go to the foreclosure sale, then they're going to have the tax liens are paid, the lender's going to get paid, and auction value. Usually there's nothing left over, because the banks that come in to buy these things. See, the thing to understand, you guys, is if whoever is doing the foreclosure, the lender that is moving to foreclose the property, anybody else that is owed money on that property are not going to get paid, because they move into that position and they can foreclose or wipe out other lenders. Okay. So if the lender is moving to foreclose, they come in, and let's just say, like the one Richard's talking about, $400,000 mortgage, $1 million home. The lender automatically has credit for that $400,000. So the lender's coming in, it's like not only a cash deal, they're coming in as, we just want the title. So you still go through the auction process, but the lender's got the money sitting there, or you're going to have investors with money sitting there. And these are people that have a lot of money. It's not like you're going to go in as a private investor and say, okay, I want to bid on this foreclosure. That is a possibility. But the banks tend to come in and they can buy it, and their cash is, they got lots of cash. So you lose your equity, and don't think that in the foreclosure sale, there's going to be this huge big bidding war. You're going to get fair market value. One of the things that we're talking about that he's done recently is we stopped the foreclosure sale, and it was a reorganization plan. That's the Chapter 13. So you're not like, it's not wiping everything out. What you're doing is you're stopping the foreclosure, stopping the creditors, and putting together a plan. And part of the plan was, we're going to sell the property, fair market value, and we're going to pay the creditors. And the bankruptcy actually allowed time to do that. Without that, I mean, there's no way we could have stopped the foreclosure sale and suspended it for 6 or 8 months.
Yeah, this creditor was ready to foreclose, and again, I think we have a sale today, and like I said, he's going to walk away with, I think, more than $500,000 to start again. And yeah, otherwise, I think he probably would have gotten nothing because he has both the mortgage lender and some other priority creditors like the IRS. So with an auction sale, he probably would have walked away with nothing.
Interesting. And control. It's about control. I mean, a lot of people I know get nervous about bankruptcy. Oh my gosh, bankruptcy, that seems so terrible. It's in the first article of the Constitution. I mean, Article 1, Section 4, Section 8, Clause 4. It was one of these things that our nation was put together, got rid of debtor's prison, made it so people can, if you trip up, if you got this, like in that commercial, help me, I've fallen and I can't get up. That's what sometimes the bankruptcy is for. And the other thing that I wanted to talk about is on chapter 13. And this is where people have severe tax issues. So let's say, for example, that you got audited and it was a big deal and you lost big. I mean, whether your professional didn't work it right or you didn't work right, something happened and now you owe money post audit. What do you do? I mean, can you actually appeal it? Can you get any more time? And I mean, we know initially in an audit, if it doesn't go your way and the examiner issues the audit report, you can say, I want to appeal it. So it goes to the manager. The manager typically agrees, I want to appeal it again. So that it might go to the appeals department. But we've had cases where it was more serious than that. And we actually needed like a judge's determination. Do you want to go to tax court? Do you want to pay the tax and then sue the IRS for a refund? Or there's a third way, and that is in bankruptcy court. And the way that works into chapter 13, we're going to talk about coming up next on if the IRS has to put in a claim, they have to kind of stake their claim and we can fight that. We're going to talk about that coming up next here on The Word on Wealth with Gary Quackenbush and Rich Mathurin.
You don't need to know everything. You just need to know where to find. About this broadcast outreach, The Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
All right. So we're talking, and we don't want to get too crazy technical, but radio, we can't get too technical anyway, but there's this interesting thing that happens is like, if you have an IRS situation, you get audited, you disagree with it, you think you just basically, it just didn't go well. And there's 50 different reasons why it may not go well. So let's say then the IRS is coming after you after an audit and you don't like the results of the audit. Well, sometimes there's tax court. So there's a couple ways to do it. One is you can pay the tax, write a check for it, literally pay the tax, and then you sue the IRS for a refund and say, oops, I overpaid, I want to sue for a refund. And then they'll have to reconsider the audit. But there's another way, and that is in bankruptcy court and under chapter 13. So Rich, talk to us about, like, so let's say there's a Chapter 13 filed. What is a creditor's responsibility? What does a creditor have to do to kind of participate in this Chapter 13 thing?
They have to file what's called a proof of claim, where they detail what they're owed, a copy of their financing agreement, or if they're a taxing authority, the tax assessment, and they have to file that proof of claim with the bankruptcy court, with the Chapter 13 trustee. The Chapter 13 trustee and the debtor all can approve it, or they can object to the claim
Okay, so the IRS comes in and they file this claim, and you look at it and you go, "Yep, that's what they're coming after me for," and you feel like you have good ground to fight it. So you're saying that in bankruptcy court, we don't have to just kind of roll over and say, "Oh, well, I owe that." You can actually object to the claim.
Yes, you file an objection to the claim with the bankruptcy court. And I think one thing that you've mentioned on numerous occasions, Gary, that's a really good point, is that the bankruptcy court is a court of equity. They're very, very pro debtor. I think they would be much more receptive to these type of arguments on behalf of the debtor against the IRS, whereas the tax court is very, very rules, and you have to provide receipts for every disallowed expense. And tax court is a hard way to go to try to prove your case, whereas the bankruptcy court is more of a court of equity that's really pro debtor. And I think you can make better arguments on appealing an audit determination.
And I think the interesting thing, and those are all really great points. And the other thing is, if you think about it, is the IRS is federal, right? And so they go by federal law. And so is the bankruptcy court, right? The bankruptcy court's federal. So we have judges in the bankruptcy court who are federal judges. They used to be district court judges, and then a while ago they made it so that there's specifically bankruptcy court judges, but they're federal. They understand federal law. They're federal judges. So you have federal IRS and federal bankruptcy judge. And like Richard's saying, and I couldn't agree with you more. I mean, it is, bankruptcy court is a court of equity. It's and you get more favorable treatment. You get federal judges who understand federal law. And we've had some really good success with fighting IRS claims. Believe it or not, you're trying to get rid of or reduce penalties, fighting over interest, fighting over, evidence providing. And you can actually, it would seem funny, but I mean, the potential is, if you're suing an objection to claim, it's going to stay in bankruptcy court. I mean, the judge could say, I don't want to rule on this. I'm going to abstain, and I'm going to, withhold jurisdiction, and I'm going to turn it over to tax court and let them decide. Because that happens in state court, but I've never seen that in federal court. The judge usually wants to go ahead and take it. It lets us put on evidence and try it. So it's not like, I mean, yes, it is. It's kind of like getting a second bite at the apple. If the audit goes badly, sometimes the way to do it is you do a bankruptcy court thing, you file the petition, they file their claim, you do an objection to claim, and then that's how you end up litigating in bankruptcy court. But, sometimes, I mean, we've seen some big numbers. The IRS, when they come in with numbers and they go, "Oh, well, they change your return from last year," and then they go, "Wait a minute, let's go the year before. Oh, and let's look at the year before." And sometimes they're, it's not just 1 year audit, it's 2 year audit, then it's 3 year audit. And then they want to see the return that you've got coming up. So, and if you're filing returns late, which a lot of people do, you end up getting in trouble with late filed returns. So you may end up having 3 or 4 or 5 years open where the IRS is coming after you. And sometimes you just don't want to be in the middle of an audit and have the IRS just kind of taking things and collections. And sometimes we just have to go to the bankruptcy court and get some help.
Yeah. Having that automatic stay and having them work through the bankruptcy court, and having yourself, you can work, with the judge. I have found that the bankruptcy judges here in the Southern District of California, that handle cases in San Diego County, are very knowledgeable, very fair, and, good to work with about and understanding the debtor's case. So, the head judge did just retire, and so I believe they have to appoint a new judge to replace her. But otherwise, the 3 existing judges are very fair, I think.
Interesting. So I think that's part of what we're trying to show is that I know bankruptcy sounds terrible, and we think, "Oh my gosh, I have to walk around with a barrel over me, and I'm going to lose all my property." That would only be if it was really messed up and you weren't adequately represented. But we've been, getting really good success. Like, most of the stuff we end up dealing with have tax issues. If you do have tax issues, it's probably not your only financial issue. You may have a tax issue, and then that leads to your inability to keep up with other things. So you have debt issues, and then you end up having your house. I mean, we're dealing with, federal tax liens on houses going into foreclosure with the federal tax lien.
1 minute.
Settling claims with the IRS. There's a lot of things that can be done in bankruptcy.
Yeah, I want to say I've in the last 6 months, I probably have seen it all. So don't think that your case is something of an outlier. We have dealt with a lot of different things, and I have a very good knowledge of the workings of Chapter 13 and working with the trustee and the judges, like I said. So it is a good process for somebody if you do have an imminent foreclosure or mortgage arrearage.
All right. So that's it for today. Thanks for being along. We're going to be back tomorrow, same time, same station. Rich, I want to thank you for coming on the show again today.
Thanks for having me.
All right. As always, this is Gary Quackenbush and Rich Mathurin here on The Word on Wealth. And we'll be back tomorrow, same time, same station. Everybody have a good rest of your day. Happy Monday.